do some things on the record before we bring them in. Do council have anything to do as well?
Just briefly, Your Honor.
Okay, so, I'll let you go first and then I'll say some stuff. Well, actually, no, I'll go first. We are on the record in case A 21844652C. Anna Marie Echevarria versus Zaon Collins. We are outside the presence of the jury. Can I just have counsel put their names on the record, please?
Ramzy, Ladah for plaintiff.
Joseph Chu for plaintiff. Good morning, Judge.
Stephanie Zinna and Paterno Geroni for defendant Zaon Collins.
And Tyler Watson for Marvin Collins.
Okay. So the order I issued on April 28th was upheld with the writ. I said I was gonna follow up with counsel about the letter. Did you get the letter in your possession that I referenced?
Yes, Your Honor.
Okay, so you have that.
I have that.
Okay, thank you. Okay, counsel, what did you want to do? And then I will say something else too.
Oh, just, there's two quick things, Your Honor. The first is, during Mr. Zaon Collins' testimony yesterday, we show, or not yesterday,
Friday.
last week, Friday. One of the tickets we showed said, it was a violation for no insurance,
No proof of
no
insurance.
proof of insurance. We accidentally didn't have that redacted. I noticed it when it went up on the screen. No one pointed it out, but it did go up on the screen. We now have it redacted. We we exchanged the redacted version for the unredacted version in the exhibits, Your Honor.
Okay, so there's been like a swap out of, did you
Correct.
swap it out with my clerk as well?
Correct. And when I saw it on the screen, I tried to pull it down as quickly as possible without making it look like something was going on, so.
Okay,
Just be
anybody
honest.
else want to make any other kind of record pursuant to that, or think that there needs to be more of a remedy than what's occurred?
No, no objection to that, Your Honor. And I discussed with counsel, we do have one more redaction to make in another exhibit, but we'll get together and we'll do that in the next couple of days. It's with respect to the body cam footage.
Okay. Okay, so I wanted to talk to counsel about the apportionment issue. Before you guys spend a bunch of time briefing it, and I wanted to tell you where I was leaning after I thought about it some more. I don't know if it was obvious last week, but I probably wasn't as solid on it last week either. But as I thought about it more this weekend, and thought about you guys spending time briefing it, I'm not precluding you from spending any time briefing it, but I want you to understand that I am very inclined to permit it to go to the jury. Okay? I don't see that changing. I'm not saying that I am 100% absolutely never changing my mind, but I think we potentially cause more harm by not putting in front of the jury. We can always brief this issue after the trial, which counsel might prefer anyway, because you can always cross out a section of the verdict form, but it's really hard to, well, we can't go back and do it again with an apportionment if we don't allow the apportionment the first time. We'd have to do the whole trial again. Additionally, there was something else that was on the tip of my tongue about this issue. Oh, I don't see how it affects damages either. So if you do want to brief this, my issue is I don't see where we cause harm by putting this in front of the jury. And I am agreeable, or I'm perfectly fine. You've made your record that you've made a record of the issue. I'm perfectly fine if counsel want to, with the understanding that I'm very likely to allow this to go to the jury. If counsel want to do this briefing after the trial and we explore it like a week or two after the trial, instead of you spending valuable hours now focusing on this, when I'm telling you that I'm very likely to allow it to go to the jury. I understand the concerns. I understand, at least I think I do. I probably don't have everything that you guys would want me to look at, but I think I understand where both parties are coming from. I also think there was at least somewhat notice here. Just judging by the fact of what was on the proposed verdict forms that came to me previously. And I'm telling you now that I'm likely to allow this, and I told you that the beginning when you brought it up on purpose, because I want to make sure that you're able to ask the questions you want to ask of every single witness. So does anyone want to make a record of that, or do you want to talk to each other during the next break and see if you might want to stipulate for me to hear this issue after the trial instead of it breaking up and hearing it before you do your closing? I'm fine either way, but I will tell you too, I will have more time to really look at all the cases you cite in your moving papers if we do it after the trial as well.
What I'm hearing, and I want to make sure I'm understanding correctly, is you're not saying that the comparative should be permitted. You're saying that at this time, you're thinking to avoid an appellate issue, to let the jury decide on it, and then we brief it after the trial, and if you somehow come to the conclusion that it shouldn't have been permitted, if they put a percentage on the plaintiff, you can always cross it out at that time. Is that what you're saying, Your Honor?
For the most part.
Okay.
It's not even just to avoid the appellate issue, it's to avoid the fact that if, if we do it wrong, then we'll have to do the whole trial again if it doesn't go to them, but we could, if we allow it, it can always be crossed out. And what I generally think too, and correct me if I'm wrong, is I don't think the comparative or allowing you to apportion affects the ultimate amount of damages. And if I'm wrong, and in some way it does affect the ultimate amount of damages, now I know it affects the ultimate amount of damages awarded to your client once you do the percentage part, but it shouldn't actually affect the ultimate amount of damages you're claiming are related to the incident.
I tend to agree. Now that I'm thinking about it, Your Honor, my only thought is usually there is a question that says, if your percentage is more than 50% on the plaintiff, then don't go on to the numbers section. Or the
Yeah.
right of the numbers, if that makes sense. So if that happens.
Oh,
Am I making sense? If
yes,
that
you are
happens,
making
if they
sense.
put more than 50% on Mr. Echevarria, and then they don't write in numbers, then the trial's been wasted anyways. If when we brief the issue, you decide it should not have been allowed, if that makes sense, because then we won't actually have numbers for the damages.
Okay.
Yeah.
Do you want to respond to that in any way? Do you have any thoughts with
Leave that
that?
off of the jury form that they're not allowed to go on.
Oh, you're agreeable to taking that question off the jury form?
So if we leave on the percentage, if I'm understanding this correctly, and I don't have a problem with what the court has proposed, if we just put the little section of percentages that add up to 100 and don't put on there, if this percentage is X, don't move on, and they still move on, then we should be okay. I understand that it still zeroes it out if it's beyond a certain percentage. But at least that's not, they won't just put a 0 in and leave that blank.
Okay, so I think what council's proposing, I could be wrong, is an alternate form that doesn't have that question on it, or that comment on it all that says if you've awarded more than 50%, you don't go on. So if that's what you're proposing, that does not, that you guys will come up with a verdict form that does not have that on there, that tells them to still go on.
Yes, that's what we're.
Yeah.
proposing.
And we can have something in the instructions if it's not already there that does say, even though we're asking them to go on, if they award more than 50% fault on your client, it will be a complete preclusion. It could be a complete preclusion to any award going to your client at all. Does that make sense?
Yes, sir.
Okay, so why don't you guys work together to get that form? Alternatively, I'm still fine hearing it if you want prior to closing, but I mean, how many hours are you gonna spend? Would you rather spend those hours focusing on the trial in light of my inclination to probably allow it? I just didn't want you to spend, and I'm sorry if you already spent 6-7 hours this weekend, but this is why I'm starting with this, because I know how limited time was when I was sitting at one of these two tables. And the extra 3, 4, 5, 6 hours that you spend drafting that document, you might want to spend putting together your closing or doing something else. If you guys are agreeable to that. And like I said, I don't think you're waiving the issue. You raised the issue. And I'm fine as long as counsel are agreeable to it, to hearing this on a briefing schedule post-trial.
Your Honor, I would agree with the proposal of doing it post-trial. In the event that there is no apportionment, it becomes moot.
Exactly.
It'll be a more reasoned decision where everyone has a little bit more time to get their best efforts on it. So that's what I would.
Okay, so you don't even need time to think about it.
I do not, but
Okay.
I don't want to rush anyone if we want to take time.
Do you want to take the time to think about it? You're not
We
wait,
just-
you
we
don't have to
just
waive
think-
anything right now.
Think about it overnight if that.
Yeah,
If that's
and
okay.
I mean, it's you guys that are gonna have to work on the brief sooner, because I think you put your deadline like,
Tomorrow.
yeah. So, I don't think you don't have any problem giving him like a,
I have no problem.
okay. So just think about it and let me know. And like I said, you can come up with a briefing schedule on your own if you want, before we can put a stipulation in place if you want. We can make it on the record orally, or whatever you want to do but I wanted to let you guys know where I was leaning and that I was leaning toward including it. So that you didn't spend a ton of time, valuable time right now, focusing on that if you could agree to do something otherwise. And if you do make that agreement, work together on a proposed verdict form and present it to me, as long as it's consistent, like as long as it's not giving them wrong law. I'm gonna be fine with what council proposed if they stipulate to something, okay?
Understand. I didn't want to interrupt you, but there is one more thing I wanted to bring up.
Go ahead.
Anne Marie had a little accident over the weekend. She fell down the stairs. She can't walk on her right foot. She was in the hospital overnight. She is trying to get a scooter so that she can come to trial still.
Okay.
But the issue is because of her physical condition, we were likely going to have her testify tomorrow. But it's going to be very difficult now. So we are going to be requesting a half day tomorrow if the court is going to accommodate us. So that Anne Marie can likely be the last witness. She just has enough time to try to recover before we get her on the stand.
Didn't we already plan for like a 10:30 start or 11 o'clock start tomorrow anyway?
Believe so, Judge. And yeah, we have subpoenaed witnesses and an expert lined up for Wednesday. We have 3 witnesses that we can fill in for tomorrow, but they're unlikely to take up more than a half a day. And then we would call our clients on Thursday, and we've run this by defense counsel. We advise that this may mean we don't finish by Thursday at lunchtime, but we would expect to still finish by Thursday by the end of the day. And they can speak for themselves on this, but my understanding was that they.
Okay, you guys want to say anything?
I think if we get the case by Friday, I can get, I think we have enough time on Friday to get the witnesses done and still close on Monday, which I think was kind of the original tracking plan. So I don't have an objection to accommodating counsel and Anne Marie for that. I would just again request that the jury instruction regarding the absence of parties and attorneys be now submitted to the jury, since we have this issue that has now popped up. I think it benefits everybody.
You guys stipulate to it now?
We'll stipulate to the instruction, Your Honor.
Okay, I had it somewhere, but I have a lot of stuff for this trial. So
I can have my assistant email it to the court if that's okay.
Yeah, that would be great.
The instruction does apply to both sides, right?
Yes.
Why don't you look at the instruction first?
Yeah.
It should be emailed, obviously CC'd everybody on it. And if you want to even put a page on top of it that says you both stipulate to it and file it, that might not be a bad idea. Counselor stipulating to the judge reading the following instruction at this time. Okay, so go ahead and file it and waive any previous objection rates if you want to put that there, but take a look at it. And yeah, why don't you guys file it and both sign off on the stip, just because we had such a I don't want to call it a do, but just because we made a record about it earlier and that wasn't everybody's position. Okay, also, I don't know if you guys have discussed it, but have you discussed what you are and are not going to be saying about her condition if she comes in here with
I mean,
a scooter?
we intend to have her explain.
Okay,
I think that's fair game, Your Honor, with all witnesses that are parties that haven't been here.
you said she fell down the stairs?
Correct. It was the last stair and she basically missed it and went down on her foot. And
Wasn't here, right?
No.
Oh, because like with the trouble we have with the elevator, people are in the stairwell all the time. And yeah, okay. Anything else before we bring them in?
I am just to address that, I don't have a problem if they say that she got injured. I just, going into the details of falling down the stairs, maybe going a bit too far, but, I think it's different if she fell down, just missed that last step versus fell down the stairs.
She didn't fall all the way down.
Yeah, like that's what I
That's-
envisioned when you
no.
said she fell down the stairs. So just making sure that we're clear on that, I would appreciate that.
Okay, I'm texting my marshal right now,
To minimize her injury.
um,
I don't-
because we're
Connor
ready for
Faker.
them
Yeah.
after,
Exactly. I'm not
Sorry,
saying
Judge.
that. Sorry, Judge.
no, it's fine. After this issue, we're ready for them to come in, right?
Yes.
Okay,
Yes, Judge.
I'm letting, we are ready. You guys can talk about what is and isn't gonna be said or whatever else. I think that's, well, I hope it's a minor issue. Thanks, guys.
Thank you.
Thank you.
Thank you, Judge.
Single chain, which one was structured? And then I will. Let me know.
Oh, when you come up here, keep your distance. I do think it's allergies, but it's very possible I have a cold too. I think I got run down and I got sick, so fine to keep your distance if you want to. If anything's really complicated, we'll actually take a break so that no one has to come near me, okay?
No,
Thank you.
thank you.
Oh,
Oh, and Judge, we should have mentioned that she is logged in via Zoom.
okay, do you want her name displayed? Or do you want it to just say observer?
I think her name being displayed is fine. Whether the jury actually sees it or not is another question, but there's no.
Okay,
Anyone else from Zoom to be in this?
So the only one, possibly two witnesses we anticipate testifying via Zoom. One later today, they've been instructed. They don't even have
No,
all
thank
the
you.
information and they've been instructed not to attempt.
I'm gonna be right back. I forgot those. I read their expert. report.
Marie Echevarria is the one who was definitely testifying.
That's.
We're just waiting on one more person that is apparently coming up the elevator right now. Who's going first, Kelly or Hirschfeld?
Dr. Kelly is going first, Judge. Dr. Hirschfeld is slotted in for early afternoon, presumably whenever we get back from lunch. We have one witness in person that we should be able to squeeze in between. He should take 30 to 45 minutes. I'm not sure if there'll be any cross of him. I imagine it's short. Jason Robledo. Okay.
And Kelly has these two reports, right?
Yes, Judge. You have copies, it sounds like?
Yeah, I went over, somebody gave me theirs, so that's what, I don't know this is, but these are the ones I read.
They were from my binder and they should not have any notes or anything on them.
No, they were clean.
Yeah.
Well, they have notes on them now, but they were clean when I got them. Thank you.
All right.
Everyone can please be seated. Did council acknowledge the presence of the jury?
Yes, John.
Yes, Your Honor.
Yes, Your Honor.
Okay, thank you very much for returning, ladies and gentlemen. At this time, we're just gonna go ahead and continue on. Plaintiffs' counsel, are you ready to call your next witness?
We are, Judge.
Go ahead.
Plaintiff's called Dr. Raymond Kelly.
It's a different setup in here, where the box is over here instead of right next to the jury. My clerk will swear you in if you can just face over there.
You do solemnly swear the testimony you're about to give in this action should be the whole truth, nothing but the truth, and your paid penalty of perjury. Please state and spell your first and last name for the record.
Raymond, R-A-Y-M-O-N-D, Kelly, K-E-L-L-Y.
Get seated, and then just be sure to hold that microphone real close to you when the little red button is up or on.
You can tap it if you want to test it. Just give it a little tap with your finger. No,
Mike.
the mic. Okay, I think it's on. Thank you.
Good morning, Dr. Kelly.
Morning.
Can you please walk us through your educational background, starting from undergrad?
So I went to Washington State University and got a Bachelor of Science degree in biochemistry. Then I went to graduate school at University of Oregon, got a PhD in chemistry. And then I had a 2-year postdoctoral appointment at Case Western Reserve University. That's in Cleveland. And that was in forensic toxicology.
And correct me if I'm wrong, your chemistry PhD at University of Oregon, did you specialize in, was it biochemistry and molecular biology?
Yes, that's correct.
So you finished your postdoctoral appointment in 1977, is that right?
Correct.
Is it fair to say you've been a practicing forensic toxicologist at least since the early 80s?
Yes.
All right, hopefully I'm louder now. I'm not going to go through every position you've worked since the 80s. Just want to confirm a couple of your longer tenured appointments. Did you serve as the director of toxicology at Associated Pathologist Laboratories in Las Vegas from about 93 to 2000?
Yes.
And then you were the lab director for National Medical Services, Inc. in Alameda, California for about 5 years, starting in the year 2000.
2 years.
Okay, thank you. And you were the lab director for American Toxicology, Inc. here in Las Vegas from about 2013 through 2022. Does that sound right?
Yes.
All right, and all said and done, were you a licensed lab director in Nevada for a period of approximately 20 years?
Somewhere in there, yes.
And it looks like you are the principal of a company called ToxTech based in Henderson. Is that right?
Yes.
Can you just give us a Reader's Digest explanation as to what ToxTech is for anyone who does not know?
It's just my own personal company, consulting company.
Okay. And you perform forensic toxicology services in that role?
Yes, that's right.
And just gonna go through your CV a little bit more if you don't mind. Dr. Kelly, have you been asked to present to various entities and law enforcement, district attorneys, groups of that nature on areas of forensic toxicology?
Yes.
Can you give us a few highlights that you're able to recall off the top of your head about some of the presentations you've made?
I think I gave several presentations to the California District Attorneys Association. And I also gave a couple of presentations back east at Harvard University for the National Council for DUI Defense, I believe it is. I'm not sure.
Okay, so you presented to both.
You haven't mentioned professional organizations. Of course, I've done dozens of those.
Oh, all right. Well, Dr. Kelly, tell us about any professional organizations that you're affiliated with.
Currently, that would be the California Association of Toxicologists and the Society of Forensic Toxicologists. And for decades, I was part of the American Academy of Forensic Sciences toxicology section.
And jumping back to the presentations that you touched upon, the presentation you made, or at least one of them, to the California District Attorneys Association, was that on a category entitled Laboratory Aspects of Marijuana?
Yes.
And it looks like you gave a presentation to the California Association of Toxicologists entitled Interpretation of Toxicology Findings in Fatal Accidents. Is that right?
Yes.
Are you published in the field of forensic toxicology in terms of works you've personally authored?
Yes.
Approximately how many different works have you published?
Roughly 20 in that realm, and then another 5 or so in physical biochemistry and molecular biology.
And today we're here testifying about a civil case. Have you also been retained to do any work in the criminal sector?
Yes,
How long have you been doing work in the criminal sector?
certainly since the early 90s.
And so when you are working in the criminal sector, are you hired by district attorneys, or how does that work?
Primarily, it's district attorneys, sometimes defense attorneys.
Okay, so you're retained by both district attorneys prosecuting cases and by criminal defense attorneys defending the cases?
Correct.
And when you are retained by either district attorneys or criminal defense attorneys in criminal context, what is it that you're typically asked to do?
I review the documentation in a case, the facts of the case, the results of any toxicology testing. Basically, my philosophy is the more information, the better. So anything that I'm provided. So in the criminal context, that typically includes police reports, the results of field sobriety testing, for example, things of that nature, arrest reports. So whatever I'm given, I review with the idea of identifying any toxicology issues that there are and seeing if I can form opinions on those.
Is it typical for you to review toxicology reports and blood draw results as part of your forensic analyses?
Yes,
This might sound like a silly question if we're going back to the 90s, but can you give us a rough estimate as to the number of toxicology reports you've reviewed and analyzed throughout the course of your career?
actually, it goes back a lot further than the 90s.
Okay,
My first professional job out of my postdoc was in 1977, I believe.
okay. So going back to approximately 1977, can you give us a rough idea as to the number of total toxicology reports you've reviewed and analyzed throughout your career?
Hundreds of thousands, if not millions.
How many of those toxicology reports that you've analyzed involved analysis for the presence of marijuana or THC within those samples?
The vast majority of them, or THC metabolites at least.
Okay, and I appreciate that distinction, and we'll get into that a bit later. As part of your forensic work, are you commonly asked to analyze marijuana results in the context of impairment?
Yes,
And it sounds like you've testified in court as an expert witness a number of times. Is that fair?
yes.
Ballpark, best estimate, how many times?
Here in Clark County, probably dozens at least.
All right, and how about,
Perhaps over 100.
I'm sorry?
Perhaps over 100.
And is that in both civil and criminal cases?
Yes,
Have you testified in any courts or in any states other than Nevada as an expert in the field of forensic toxicology?
yes.
If it's a list of like 30 states, you don't need to mention it. Are you able to tell us about a few of those
Well,
states?
California, Arizona, Ohio, Texas, Idaho. Those are the ones I can recall offhand.
Fair enough. Focusing for a moment on civil cases such as this case, when you are retained as an expert in the field of toxicology in a civil setting, can you give us your best estimate as to the percentage of time you're retained by plaintiff counsel, like us in this case, versus the times you're retained by defense counsel, like my friends to my left here?
Probably roughly 80% defense.
All right. And in fact, and correct me if I'm wrong, I believe the last time you and I crossed paths, I deposed you when you were an expert for the defense side in a case where you were directly adverse to at least my client in that case. Is that right?
I recall that, yes.
Okay. I hope you recall it fondly. What were you asked to do in this case, Dr. Kelly?
Look at the information in the case and identify toxicology issues and see if I could form any opinions on those.
And what materials did you review in order to perform your assessment and see if you could formulate toxicology opinions?
I really have to look at my report because it was a pretty long list.
I should have asked you, and it looked like you pulled out a folder. do you have clean copies of your two reports in this case?
I do.
With you? Okay. They're not annotated or marked or anything?
No.
Okay. And if you want to refer to your report as a reference or to refresh your recollection, you may. So if doing so would help you answer my last question, feel free to go ahead and take a look at that.
Okay. So you asked what sort of documents I looked at.
And if you could just let us know the date of the report you're looking at and the page that you're looking at as well.
July 4th, 2024, page 1.
Okay.
So Las Vegas Metropolitan Police Department or Metro reports, records, narratives, and witness statements. And then I've broken that down to some extent. The Metro impaired driving report, the Metro standardized field sobriety test record, Metro's declaration of arrest report, voluntary statement of witness Robin Lee, State of Nevada traffic crash report, Metro report of examination, seized drugs, Metro collision investigation supplement, incident body cam videos, Metro declaration for the withdrawal of whole blood samples, 2 toxicology reports, Metro forensic lab, 2 guilty plea agreement, judgment of conviction, defendant Zaon Collins supplemental answers to plaintiff Anne Marie Echevarria's interrogatories, and the defendants, I'm not going to say all that stuff again. The defendants' responses or answers to plaintiffs' requests for admission. And then I always throw in a catch-all term, miscellaneous documents in case I forgot something.
And did your review of the materials that you just went through for us allow you to formulate toxicology opinions in this case?
Yes,
And correct me if I'm wrong, you ultimately did draft a supplemental report in January of this year, is that correct?
correct.
And I believe you had reviewed defendant Zaon Collins' deposition transcript as prior to drafting that supplemental report?
Yes.
Okay. Now, in this case, Dr. Kelly, was the defendant Zaon Collins tested for drugs in his system following the December 30th, 2020 motor vehicle crash?
Yes.
First, what type of sample was collected from Mr. Collins to that end?
Blood samples.
And what time was the blood draw performed?
I'm remembering that it was 1752 or 1652 and 1752, something like that, 2 samples,
And
about
you're,
an hour apart.
and you're stating military time, is that right?
Correct.
Okay, so 1652 and 1752 would be 4:52 and 5:52 PM.
Correct.
And you mentioned 2 blood draws. Is that normal for 2 blood draws to be performed in this type of situation?
Yes.
Why is that?
It's just the policy of the district attorney's office. And I think it does respond to a previous decision by the Nevada Supreme Court as well. But basically, in a case involving death or serious injury, usually referred to as a felony DUI case, then 2 samples are usually taken. If it's misdemeanor DUI, they don't always take 2 samples, sometimes just 1.
So the accident occurred based on what the evidence shows at about 3:20 PM. So by my math, the fact that these blood draws were performed starting an hour and a half after the crash, is the timing of these samples appropriate in your view in terms of being useful from a toxicology standpoint?
Yes.
Joe, can we put up exhibit 10, page 1? This is pre-admitted. All right. And Dr. Kelly, do you have that up on your screen there?
I do.
We'll zoom in as needed as we go through this document. Does this appear to be at least the first page of Las Vegas Metro Police Department's forensic lab toxicology report for Mr. Collins?
Yes.
All right. And I say Mr. Collins, we have two defendants, both with the last name Collins. If I do so, you'll understand I'm referring to Zaon Collins.
Correct.
All right, I'll try to be specific. And I know you reviewed a lot of documents and other materials in this case. Is this toxicology report amongst the items you reviewed?
Yes.
Joe, can you zoom in there on the two testing portions? Yeah, starting perfect. There you go. Okay. Based on your review of the toxicology report from Metro in this case for Mr. Collins, Zaon Collins, can you explain and walk us through the process through which his blood was analyzed?
Yes, I think so. So the testing was done in two stages, what we refer to as screening and then what we refer to as confirmation. The screening test was by a method called immunoassay, which uses antibodies and detects drugs by in the sample by their overall shape. And as you might expect with that type of test, it can produce a positive response with other substances that are closely chemically related. For example, there are over 100 different compounds in the cannabis plant. And if you develop an immunoassay for THC specifically, you're going to pick up other components of the plant as well as metabolites in the human body, which is okay because you're doing a screen. In other words, you're basically distinguishing whether the sample has any drugs in it. And they do test for other drugs besides the marijuana components.
Okay, and then you mentioned the second stage being a confirmation analysis.
Correct.
Can you walk us through how that is performed?
So that's done by a method called mass spectrometry. Currently, I think it's LC or liquid chromatography tandem mass spectrometry. But the key thing about mass spectrometry is it really identifies the individual compounds that are there and measures their concentration.
So it looks like the immunoassay screen, step one of the two-part test that you just walked us through, was performed on January 4th of 2021. Do you see that, Dr. Kelly?
I do.
So that's about 5 days post-crash. Does the fact that the immunoassay screen was performed 5 days after the crash cause any concern for you from a toxicology standpoint, or is that normal?
It's actually really great.
How
A
so?
lot of labs can't do it that fast.
So you would characterize that as a quick turnaround, is that fair?
Absolutely.
All right, and then it looks like the confirmation testing was performed over the course of, I guess, 2 days, January 5th and January 6th, which would be about 6 and 7 days post-crash. Do you see that?
Yes.
So first, why did this test span 2 days?
It's very, very common to prepare a sample and put it on the instrument and let it run overnight, and then come back and look at the results the next day.
And the fact that the confirmation portion of the testing was completed at the time it was, 6 days post-crash, does that present any concerns for you from a toxicology standpoint?
No.
So if we look at the results of the immunoassay screen, it looks like for cannabinoids, it states further analysis performed, see confirmation analysis below. You see what I'm referring to?
Yes.
So does that mean that the immunoassay screen, for lack of a better term, was positive for or red flagged for the presence of cannabinoids?
Yes.
What are cannabinoids?
Marijuana components, substances related to tetrahydrocannabinol, which is the primary active component of the plant. The plant is known as cannabis, so that's where you get the term cannabinoids.
Is the tetrahydrocannabinol, is that commonly referred to as THC?
Correct.
Did I say it right?
That's very good.
Close enough. All right.
We've been practicing.
All right. And you mentioned a process within the confirmation testing, I believe, called mass spectrometry. Is that right?
Yes. Very good on that one too.
Thank you. When testing for the presence of marijuana in blood via mass spectrometry, what specifically is being measured for within that test, as we see here?
Well, as I said, you're measuring Well, the technique is based on us subjecting the molecule to an electronic signal, basically a charge, which causes the molecule to fragment into characteristic pieces. And those are what are detected and allow you the ability to identify exactly which drugs are present and measure their amount.
Okay, and Joe, can you zoom in just on that confirmation analysis table there on the bottom? There we go. Oh, perfect. Thank you. So when we look at the confirmation testing here, what are the items that we're seeing beneath the heading drug?
So we see, first of all, something known as THC carboxylic acid, which is a metabolite of marijuana or metabolite of THC specifically. The next line item is delta-9 tetrahydrocannabinol, which is THC itself.
And what is the purpose for, well, you know what, actually, let me go back a bit. What is the purpose for testing marijuana in these two stages, the immunoassay screen and then the confirmation testing? For example, why not just shortcut it and jump straight to the confirmation testing?
Well, just to produce a more reliable result, because you have two different methods that differ in their chemical principles that you're applying to this sample. So if it pops positive on both, and I explained earlier that the screening test isn't absolutely specific, like the confirmation test is. Other similar things can cross-react, but this particular immunoassay is quite specific for something related to THC. So it's not going to produce a positive response with other drugs or dietary components or anything of that nature.
Is it fair to say that the two-step process, if I understand what you said correctly, is a means to ensure or increase the accuracy and the validity of the results?
Yes.
So looking again at the confirmation analysis findings for Zaon Collins, what is the purpose of screening for both of these two components in this type of drug test, the marijuana metabolite and THC?
First of all, it enhances the specificity of the test. It's one more indication of the fact that you have the right result. If you have not only the THC present, but you also have the metabolite. So it's gone through somebody's body and it's produced that metabolite. It adds to the specificity, and there are also things that you can do with those concentrations in terms of estimating the time of last use.
All right. And what were the results of Mr. Collins' test for THC?
So it was 3 nanograms per mil. Mil being short for milliliter.
All right. And are you familiar, Dr. Kelly, with the legal threshold in Nevada for THC for operators of motor vehicles?
I am.
And what is that threshold?
2
nanograms?
2.0, yes.
Okay. And what were the results of Zaon Collins' test for the marijuana metabolite?
So that was 32.4 nanograms per mil.
And are you familiar with the legal threshold in Nevada for the permissible amount of marijuana metabolite by nanograms per milliliter for operators of motor vehicles?
Yes, at that time it was 5 nanograms per mil for this compound.
And what is it currently?
What they did is they changed carboxy THC is what I call it for short. They changed that out and they put in another substance known as 11-hydroxy THC. And they did that because carboxy THC is inactive. Actually, the analysis still encompasses carboxy as well, but the legal standard now for what we refer to as the per se level for these drug components, they they made it 11 hydroxy. They left it, the same number, 5 nanograms per mil, but they changed it to another compound. But the way the crime lab does the test, now they test for 3 different things. So the THC, the carboxy THC, and the 11 hydroxy THC.
Did the Metro's crime lab abide by the standards that were in place at the time of this collision about 4.5 years ago?
Well, yes.
Let's see if my math is right. And I believe you said that among the reasons why these 2 compounds are tested for is because they lend some insight into the recency of use. Did I understand that correctly?
Correct.
So when you look at these 2 results together for Zaon Collins, what do these results indicate to you, Dr. Kelly, from a toxicological standpoint?
Recent use of marijuana. For example, these would be pretty typical results if somebody smoked a joint within a few hours of the time the sample was taken.
Is your last statement specific to smoking marijuana only as opposed to other forms of ingestion?
Other forms of ingestion, you're pretty much going to get the same time frame. For example, nowadays you can vape THC. You can also ingest it as an oral product of some sort.
Okay, so you said that these results are consistent with someone who used marijuana in one form or another within the preceding few hours?
Yes.
And how are you able to arrive at that opinion?
Just understanding the way that the body handles THC and other marijuana components in what we refer to as pharmacokinetics. It's basically the time course of drug concentrations in the blood. And there's also very time-honored models for calculating the time of last use that have been around for around 30 years or so. So they're pretty reliable. They're still used. Where you can use these 2 numbers here, the carboxy THC number and the THC number, to calculate an interval for the time of last use. And I did that in this case.
And you said a few hours in terms of recency. Did you come up with a more specific interval or a range for the time frame that, in your opinion, Mr. Collins would have likely consumed marijuana prior to the crash?
I did.
And what was that time interval?
0 to 6.5 hours before the crash.
All right. Did you review any evidence in this case containing statements made by Zaon Collins about his history of using marijuana prior to the December 30, 2020 crash?
I did.
And what do you recall? What do you recall reading in that respect?
I recall that there were several statements made that were, some of them kind of inconsistent with others. But I think the bottom line was on his deposition that he said he consumed 2 THC gummies 2 to 4 days prior to the accident.
Okay. And you also reviewed Mr. Collins' responses to interrogatories, I believe?
Yes.
All right. All right. Now, are the results of Mr. Collins' post-crash blood test, as we see up here on the screen, Exhibit 10, consistent with someone who consumed 2 gummies 2 to 4 days prior?
No.
Can you explain why not?
Because that's been studied. So I mentioned the term pharmacokinetics, which is, again, the time course of drug concentration in the blood. And that's been looked at not only for smoking marijuana, but also for ingesting it in an oral form. And there was a study where they had people, I should just parenthetically say that I found that in the state of Nevada, a product has to contain a maximum of 10 milligrams of THC. So for example, 1 gummy can't contain more than 10 milligrams of THC. So if he ate 2 of those gummies, that would be 20 milligrams. So in this particular study, they looked at a number of doses of THC administered orally, which means, by mouth. And if I recall correctly, they looked at 10 milligram dose, 25 milligrams, and 50 milligrams. So I focused on the 25 milligram dose because it was similar to what we have here in the case potentially. And what they discovered is that one, the average maximum concentration of THC after consuming 25 milligram oral dose of THC was 3.5 nanograms per mil. And they had a detection limit of 0.5 nanograms per mil. Below that, they would call something negative. And they found that all of the participants in the study tested negative within 22 hours. So that's less than 1 day. And here we have 2 days, perhaps a little more. So therefore, to get to kind of the bottom line, I would expect if Mr. Collins' scenario was what really happened, I would not expect him to be testing positive for these compounds at the time of his blood sample was taken.
When you say Mr. Collins' scenario, just to be clear, are you saying that if we were to take Mr. Collins at his word that the only time he used marijuana prior to the crash was eating 2 gummies 2 to 4 days prior, that you would have expected that THC to have passed through his system by the time he was tested 2 to 4 days later?
Correct.
And the various studies that you're mentioning in models, I believe you referenced a number of these in your report. Is that correct?
That is correct.
And are these studies that are peer-reviewed and are adopted and widely used in the field of forensic toxicology?
Yes.
Now, the fact that the blood draws were performed starting 90 minutes post-crash, does that mean that Mr. Collins' THC level was actually higher, more likely than not, than 3 nanograms per milliliter?
Objection, Your Honor, calls for speculation also outside the scope.
Response.
Your Honor, this is a very basic extrapolation that would be commonly performed by a forensic toxicologist under these circumstances, and it's really just a yes or no answer.
Okay, but where in his report does he say he's gonna give an opinion like this of what?
Your Honor, I can circle back to it. I will get there. I can
Okay,
move
let's
on
do
for
that.
now. Thank
So you're
you.
gonna skip it for now?
I will, Judge. Thank
Okay,
you.
thank you.
Dr. Kelly, as a general proposition, can the consumption of marijuana impair one's ability to safely drive a motor vehicle?
Yes.
And can you explain to us or walk us through some of the ways in which drivers are commonly impaired by being under the influence of marijuana?
Yes. THC binds to a specialized protein in the central nervous system, which is the brain and spinal cord, known as a CB1 receptor. And that's how it exerts its effects. And those effects are on cognition, which is the ability to think, reason, make decisions, as well as being involved in the initiation of motor movement and the continuation of motor movement, which is basically moving your body, which in a driving context could be things like steering the vehicle.
Are you aware of any studies which analyze the likelihood of drivers with THC in their system getting into motor vehicle accidents compared to drivers without THC in their system getting into motor vehicle accidents?
Yes.
Can you just tell us
So
a
there
bit
was an
about that study?
Australian study which looked at culpability, which is who's to blame for an accident, responsibility, in other words. And it was discovered that if you have any detectable THC in your blood post-accident, that you're 2.7 times more likely to be in a crash and to be actually the cause of that crash than someone who's unimpaired.
And are you aware of any studies? You said that was an Australian study, is that right?
Yes.
I guess more locally or to at least the United States, are you aware of any studies performed by the, for instance, the National Highway Traffic Safety Administration regarding the effects of even low doses of THC on driving?
Yes.
Can you tell us about that?
And that's really more of a general statement based on all of the literature rather than being in other words, it's not a primary source. Instead, what it is a summary of literally hundreds of primary sources or scientific papers.
A
And
compilation?
they made a summary statement to the effect, if I could refer to my report.
Yeah, please just let us know what page.
This would be page 5. The National Highway Traffic Safety Administration Drugs and Driving Performance Fact Sheets stated low doses of THC moderately impair cognitive and psychomotor tasks associated with driving. Psychomotor means how your brain and your body work together. So for example, if you're driving and something unexpected happens and you ultimately need to brake, it's what we would normally call complex reaction time. Driving is a complex divided attention task. So you basically have to see the hazard, you have to formulate a response to that, and then you have to carry that out with your body. So that's sort of a 3-stage process, and it doesn't happen instantaneously. So marijuana can impair that basically.
And you
and
said
then they
that,
go on to say,
oh, go ahead.
they call attention to the fact that the more difficult and unpredictable a task is, the more marijuana is going to impair that task. And so in the driving context, certain things are predictable as you're driving your vehicle, maintaining speed, responding to traffic signals, but certain things happen or can happen that are not predictable. A child running out between 2 cars, chasing a ball, and you have to be prepared to respond to those too.
And in the types of unpredictable situations, like you just mentioned, what did this study state in terms of the effects of marijuana and impairment?
So if I could actually quote it, it
Please.
basically said, the more difficult and unpredictable the task, the more likely marijuana will impair performance.
And that is a National Highway Traffic Safety Administration.
Correct, the federal agency that is concerned with traffic safety.
And I believe you said
All
this
aspects of that.
this was a compilation of data or studies that the NHTSA performed.
Yes, actually, they hired experts to do that, including many of the ones who had published the primary sources upon which this summary is based.
Does marijuana impairment, at least in part, depend on the interval of time in which a person uses marijuana and when that person drives a motor vehicle?
Yes.
Given your opinion that Zaon Collins used marijuana between 0 and 6.5 hours prior to the December 30, 2020 crash, does that interval encompass the time frame wherein, in your opinion, marijuana is likely to impair driving?
Yes.
And beyond the THC and marijuana metabolite levels being in excess of the legal limit and allowing you to draw the other conclusions that you've talked about, did you come across any other evidence in this case which, in your view, supports the notion that Zaon Collins was under the influence of marijuana or impaired by marijuana at the time of the crash?
Yes.
Can you tell us about that briefly?
Well, first of all, he was speeding, and I believe somewhere around 3 times the posted speed limit. I looked that up on the internet the other day. It was 30 miles an hour on Fort Apache, close to Furnace Gulch Road.
You talking about the speed
If I
limit?
remember those roads correctly. And it said 30 miles an hour. And honestly, I don't know if it was different then, but what it's listed as now is 30 miles an hour. And I understand that he was driving 88 miles an hour before this crash. And that was 2 seconds before impact. So that's one thing. Speeding can be a sign of drug impairment. Then there also were a couple of observations made when the police officers interacted with him. One was in doing what we call the HGN test, horizontal gaze nystagmus test. They do a test for something we call LOC, lack of convergence. It's basically the ability of the eyes to come together as a stimulus approaches the face, basically the center of the face, the nose. And if there is LOC present, that's consistent and really a sign of marijuana or cannabis in some form. Same thing with the eyelid tremors. There was a study that looked at people who had ingested cannabis, and 86% of them had eyelid tremors as compared to 6% of unimpaired people. So it's a symptom that could occur in an unimpaired person, but the odds are that it's a lot more likely if somebody has consumed cannabis or marijuana.
And it is reflective of not just consumption, but of impairment. Is that correct?
Yes, in the general sense.
Okay.
That I mentioned.
Dr. Kelly, based on your expertise in the field of forensic toxicology and everything you've reviewed, do you have an opinion as to whether Zaon Collins was impaired by marijuana at the time of the December 30th, 2020 motor vehicle crash?
I do.
And what is that opinion?
But more likely than not, he was. We would normally express it in the field as a reasonable degree of scientific probability.
And abiding by that same standard, would, in your opinion, that impairment have more likely than not interfered with Zaon Collins' ability to safely operate his motor vehicle that day?
Yes, that's my opinion.
Now, earlier you testified that you are regularly retained to perform toxicology analysis in criminal cases, including by various district attorneys. Is that right?
Yes.
And Dr. Kelly, you were actually retained by the Clark County DA to perform a toxicology analysis in Zaon Collins' criminal case arising from the same crash. Isn't that right?
That is true.
And did you, in fact, perform that analysis and prepare a report of your findings for the district attorney's office?
Yes, I did.
Right. I'm almost done with you here, but I compared the report you prepared in this civil case with the report you prepared for the DA in the criminal case. And I just want to ask you a couple of questions about some differences between those two reports. Toward the beginning of your report in this case, in the civil case, you said your opinions, as you just mentioned a moment ago, were being offered to a reasonable degree of scientific probability. But in your report for the criminal case, you said your opinions were being offered to a reasonable degree of scientific certainty. Can you just explain to us the difference between those two standards, or why you use that different language in the two reports?
So those are expressing the differences, I guess, between more likely than not would be a common way of saying it versus beyond a reasonable doubt. And I, as I've indicated earlier, function in both contexts, civil and criminal, and I'm not an attorney. I freely admit that. Although maybe that's to my credit, I don't know. But basically, I try to be aware of the context in which I'm offering opinions, civil versus criminal, and offer them in an appropriate way in those two venues or realms that I understand differ in their basic rules. And again, that's as a non-lawyer.
So you may have already answered my next question, but I just want to address it to be clear. Your report for the criminal case says that in your view, Zaon Collins may have been impaired at the time of the crash. your report in this civil case says Mr. Collins was probably impaired at the time of the crash. Can you explain to us the reason for using that different wording?
Yes, kind of, as I explained, the different standards of proof, criminal versus civil. I just, I didn't really change my opinion between the two reports. But I did not feel in the criminal context that I could get to the point where I would say beyond a reasonable doubt or a reasonable degree of scientific certainty. The way I assessed the facts, they were strongly suggestive, but I just didn't feel like I could get to that beyond a reasonable doubt standard.
So if I'm understanding you correctly, you are not able to say with certainty that Mr. Collins was impaired at the time of the crash, but you are able to say comfortably that he was more likely than not impaired. Am I understanding you correctly?
Yes.
And so were your analyses of the toxicology results and the other items you reviewed in these two cases, were they performed differently, or were the opinions you reached different with respect to the actual science?
No, not with respect to the science. In fact, I think they were largely the same as far as content. So it was only the final opinion that differed based on the context.
Okay. Your opinion in regard to the likelihood that Mr. Collins was impaired at the time of the subject crash differed in terms of its wording based upon the criminal versus civil legal standard in which you were asked to provide an opinion. Is that right?
Correct.
In either scenario, and regardless of the degree of impairment, is it your opinion that Zaon Collins was in fact driving in excess of the legal limit for both THC and marijuana metabolite at the time of the December 30th, 2020 crash?
Yes, but that's not an opinion, it's a fact based on this test. If you accept the results of the test and you accept what the law said at the time, then it's just a fact that he was above that.
Well, at any point, did you assess the likelihood that Zaon Collins' blood test results, as we have up on the screen, performed and processed by by Las Vegas Metro Police, were somehow inaccurate and that he may not have actually been above these legal limits?
Yes, it did.
And what did you determine in that regard?
Remember, I mentioned that the legal limit for THC itself was 2 nanograms per mil at the time, and currently it is still the same. And his result was 3.0. There's a figure on this report, 0.6, which is the uncertainty that the lab calculated. And I utilized that figure to estimate what was the probability that the actual result, if the test came out 3.0, what was the probability that it actually was 2.0 or less? And I came out with that probability being 0.12%. So less than 1%.
So inversely, are you saying that the likelihood that Mr. Collins was driving in excess of the legal limit for THC was about 99.88%?
Yes, that would be the
And
natural conclusion.
again, the study that you mentioned shows that drivers who have THC in their system are 2.7 times more likely to be involved in accidents for which they are culpable than drivers without THC in their system.
Without, any drugs in their system.
Dr. Kelly, have your opinions today been offered to a reasonable degree of scientific probability?
Yes.
All right, I will pass the witness, Judge. Thank you.
Does anyone need a break, or are you okay to keep going? Okay, seeing no hands raised. Defense counsel, are you prepared to cross-examine?
Yes, Your Honor.
Okay.
Morning, Dr. Kelly.
Morning. I'm good.
My name is Stephanie Zinna. I am counsel for Zaon Collins in this matter. You are a toxicologist, correct?
Correct.
Have you ever served in law enforcement?
I have not.
Are you familiar with the Advanced Roadside Impaired Driving Enforcement Guidelines, also known as A-RIDE?
Vaguely.
What is your understanding of what those are?
Well, just, you know, the use of standardized field sobriety testing, that sort of thing. I should mention maybe that when I review a case, I pretty much take what the police write down at face value as opposed to, uh, you know, trying to develop my own opinions on those matters. Because they record the facts, they're actually there and they have the training to do it. So I'm kind of forced to take their word for things. For example, if they observe a certain symptom, I'm not going to go back and say, well, no, you didn't observe that symptom.
So you're relying on the police officers in a lot of circumstances.
In many respects, the non-analytical toxicology aspects.
But that A-RIDE, those guidelines teach officers how to perform field sobriety tests. Is that your understanding?
That's my understanding.
Were you aware that the first officer to test Zaon in the field found no signs of impairment?
I don't remember that.
Exhibit 8.
Just want you to look at it with your eyes only, and I want you to hold my finger with your eyes only, keep your hands still, it's gonna go left and right. He's a driver, the guy in the table right here is the driver of this vehicle, the vehicle claims are apparently,
I had a hard time hearing that, counsel.
It was too loud?
Well, it was a little too distorted. It was loud, yes.
Okay.
Can I make a comment, though?
Well, let me ask, do you need to replay it? Is that your comment?
No.
Okay. Did you hear at least one of the officers say no signs of impairment for Zaon? Did you hear that?
I didn't hear that, but I'll take your word for it.
Okay, you did not hear that. Is there a way to turn, because the volume was really loud, is there a way to turn the volume down a bit?
He's a driver, the guy in the table right here is the driver of this vehicle, the vehicle claims are apparently,
Did you hear it that?
That time I heard it,
You
yeah.
got it. Okay. No further field tests were done at that point. Are you aware of that?
I wasn't aware of that.
Sam then went to the hospital. You understand that?
Yes, I think I viewed a video of him in the hospital.
Did you review the field analysis performed by the officers in this case when they got to the hospital?
I think that's what was in the police report, yes. In terms of the field sobriety testing, and the comment I was going to make is that they only did one of the 3 standardized field sobriety tests, which is the HGN test.
If you could please grab the binders, one of the binders behind you, and I'm gonna refer to exhibit 35, which is not.
Either one?
You're gonna need exhibit 35. I can help you if you need. Turn on
Well,
the
just
video.
tell me which book.
I don't know which book because I can't see it from here.
Oh, fair enough. So you said 35?
Exhibit 35 is what I'll be referring to.
Okay. So I've got a book that says exhibit 33 through 82.
Well, then you got the right one. If you could turn to page 35-0005 of this document. 35, pages 5 through 7.
Thank you.
Does this document look familiar to you, Dr. Kelly?
It does. I see a lot of these kind of documents.
And I believe you listed this in your report that you had reviewed it and relied upon it in coming to your conclusions,
I
correct?
believe so, yes.
Have you personally ever administered a field sobriety test?
Yes, but it was not in a field type of condition. It was at a professional meeting and with the help of highway patrol officers who were basically demonstrating to us how to perform these tests.
And for this field sobriety test, you talked about the HGN test, right?
Right.
What is that?
Horizontal gaze nystagmus is a test for involuntary jerking of the eyeball as a result of drug influence. It's not really an anticipated thing with marijuana. You don't anticipate seeing that particular symptom.
Okay. So what about lack of smooth pursuit? Do you understand what that is?
Yes.
And what is that?
That's just the smooth pursuit is the ability of your eye to your eyeball to move without any of this jerking. In other words, to move smoothly across back and forth, because the officer will move his stimulus, which is usually his finger, back and forth, and observe how the eye responds. And the eye is controlled by muscles. And so when you have drug influence, the functioning of those muscles is affected, and that's what produces this involuntary jerking.
So Zaon illustrated no signs of HGN, correct?
Correct,
No sign of vertical gaze nystagmus, correct?
correct.
And he did not have, or let me ask you it this way. Do you know what the other signs of impairment are in the field for officers to look at?
Yeah, in general, I do. For example, here, lack of convergence, and I already addressed that in my testimony. So that's specific for marijuana, although a few other things can cause that also.
And we'll get to lack of convergence in just a moment, but are you aware of any other signs or symptoms that officers are trained to look for in the field?
Well, yeah, when they do the full panel standardized field sobriety testing, then there are two balance tests. One's called walk and turn, the other's called one-legged stand. Then there are various parameters that are looked at when those tests are performed. With regard to walk and turn, for example, does a person stand still during the instructions, or do they start too soon? When they start walking, do they touch heel to toe? Do they step off the line? Do they use their arms to balance? Do they make a proper turn? Do they make the right number of steps? And there's basically 8 different, they call them clues. And over 4 clues is considered a failing result. 4 or more clues is considered a failing result on that test. The one-legged stand test, they lift one foot, and with arms at their side, they look at that foot and count out loud with the foot raised approximately 6 inches from the ground. And there can be up to 4 clues on that test. So that's the standardized field sobriety test. There's some, and when I say standardized field sobriety test, it's the one approved by the National Highway Traffic Safety Administration, or NHTSA. Sometimes, especially I've noticed the Nevada Highway Patrol adds additional tests, like the finger to nose test, the modified Romberg test.
You reviewed the grand jury testimony related to Zaon Collins' criminal file, correct?
You know, I don't remember doing that.
Okay, if you
I
could
mean, if
please
my,
turn,
because I don't have my criminal report here with me.
that's okay, we have it in front of you, you're all good.
Okay.
If you could please turn to 241 of that same exhibit, 35-0241.
41.
Are we looking at the same document? That doesn't look familiar.
I'm on that page and it looks good to me. There's something about grand jury in the second paragraph at the end. Is that what you wanted?
Maybe I'm at your report. Okay, that is your, I believe that is your report from the criminal case. Is that correct?
Correct. It looks like it. Let me just flip to the first page here. So it's directed to a district attorney as opposed to any of the attorneys in this case. And I do see that there's a couple of grand jury transcripts, so I reviewed those. So this report was in 2021, so I didn't recall all the details of it.
Okay, I don't expect you to memorize everything in a case. And in this report, had you reviewed the grand jury transcripts?
Yes, that's what it would indicate.
And you indicated as part of your opinions in this report that Officer Powell was the officer who conducted an abbreviated field sobriety test, correct?
Correct.
And you acknowledged that Officer Powell did not observe several other signs and symptoms of potential marijuana influence. Do you see that in your second paragraph?
Yes, I see that.
Okay. he did not observe eyelid tremors, coating or blistering on the person's tongue, balance issues, coordination issues, problems speaking or comprehending, cracked eyes, or an odor of marijuana. Is that correct?
Yeah, that's what it says.
Okay, and that was taken from your understanding of Officer Powell's grand jury testimony?
I believe so. I mean, there's the written reports, of course.
Of course. The THC, the THC, that's an inactive element, correct?
Yes,
Meaning that it is not psychoactive. agreed?
correct.
Okay. You talked about presenting to the DA in California, over, about 15 years ago. Are you aware that the threshold for DUI is not given in California? Did that impact your trainings or your presentations? That there's no per se threshold in California?
Objection relevance, Your Honor. Move to strike. It's different law than the state of Nevada.
They spoke about him presenting to the DA in California as part of trainings, so it would be, in support of him being qualified in this case, and it would go to his knowledge of what those presentations would be.
Okay, can I have counsel approach? We're just gonna disregard that question, okay, sir? She's gonna ask you a new question.
Dr. Kelly, would you agree that a per se limit of THC in the system may not always reflect impairment?
Yes, I would.
Are you familiar with the grand jury testimony in this case by a toxicologist by the name of Nicole Vanaken?
That's not ringing any bells.
All right, in that same exhibit, could you please turn to 0166 for me?
166, 35 dash.
35-0166. It hasn't been admitted, so can we please? Yes, thank you.
Being shown to refresh, is that what's happening right now?
Yes, because he reviewed it in preparation for both of his reports.
Okay. So it's listed in his,
It's listed, yes, he's reviewed it in his original report to the DA. And it looks like in his current report, he reviewed the criminal file, which this exhibit is part of.
okay.
Yes, and yeah. Okay, do you see that name there?
I do.
Okay, if you could turn to 174. And read to yourself lines 12 through 17.
I got it.
Do you agree that the blood work in this case is a low level for what is usually found in DUI samples?
No,
You disagree with that
I
assertion?
disagree.
Um,
Again, she's an analyst. She's not a toxicologist.
and you
With
know
all due
that.
respect to her.
Okay, and how do you know that?
Because I'm familiar with how the Metro Crime Lab operates, and I know that they don't like their analysts to give opinions on impairment, which is why the DA hires me, obviously,
Okay.
in these cases.
So she is a forensic scientist in the toxicology unit of the LVMPD's forensic laboratory. Were you aware of that?
Yes, it was,
Okay.
because I just read that.
And would you agree that THC is quickly metabolized?
I don't know what quickly means exactly.
Okay. Is THC metabolized quicker than the body gets rid of the metabolite that's left?
I don't think so. But what you're usually seeing, this gets complicated, sorry. First of all, the metabolite level starts off at 0, assuming you haven't smoked any marijuana for a while. And then it rises up and kind of flattens off actually for a few hours and winds up having an average half-life in the body of something like 5 hours. THC looks like it has a much quicker half-life because when somebody's, for example, let's take the smoking a joint, the THC concentration rises very quickly and very high in the blood, even peaking or reaching a maximum concentration while someone's still smoking the joint. And then it drops down and very rapidly, and I indicated, I think earlier in my testimony, within two hours, it's sometimes 2 to 4 hours, it's basically back to baseline. And the reason for that isn't because it's being metabolized, it's because it distributes out of the blood and to other locations within the body. It's very highly fat soluble, so it goes into adipose tissue, nervous tissue, the brain. And so it's not to be found in the blood anymore, but that doesn't mean it's been metabolized.
Would you agree that THC can stay in low levels in the body for up to a month?
Well, it depends on how you assess that. If that's based on positive urine testing, for example, then sometimes you can test positive if you were an extremely heavy user for a matter of weeks at least, if not, if not over a month. That is not what you see in the blood, however.
So if you turn to page 176 of that grand jury testimony. And lines 21 through 23. Do you then disagree with Ms. Vanaken that THC can stay at very?
Improper use of the transcript.
Response.
I did not quote it. I was giving the general overview as he's reading it. I did not read it. It was just for my own reference.
Okay, but I don't know how you're gonna finish the question. Cause it stopped, right?
I stopped, yes.
Okay, oh, so the question is withdrawn.
No, I can rephrase
Okay.
if
why
that's
don't you
the
rephrase?
problem.
Yeah.
Yes. Okay, now that you've refreshed your recollection with Ms. Vanaken's testimony, do you disagree with her assertion?
It just depends on how heavy. I think in this case I would, because he never admitted to being a heavy chronic marijuana user. And that's the kind of scenario that was studied in one of the studies that I cited in my report for this case. My second report, I did 2 reports in this case, where the study involved people who are what I would say is gargantuan users of marijuana, where their daily consumption before coming into the study was 1 to 5 blunts a day. And a blunt has a lot more marijuana in it than a joint does. And even there, the average blood level of THC on day 1 for those people was something like 0.7 nanograms per mil, if I recall correctly. I can pull my report. And it went down from there, the average level. So there were like a couple, 3 people out of 25 that were still positive on day 7, which was the length of this study. But their levels were way less than 1 nanogram per mil.
And the study you just referenced was with respect to chronic users, correct?
Yeah. I think if somebody smokes 1 to 5 blunts a day, they're a pretty heavy hitter when it comes to marijuana, in contrast to Mr. Collins, according to his statements, at least.
Correct. Okay. You're familiar with, and I think you've cited to a few of the articles, you're familiar with the government publishing the website PubMed.
Yes, ma'am.
Okay. Are you aware of a publication from 2019 entitled Cannabis Use as a Risk Factor for Causing Motor Vehicle Crashes? It's authored by Brubacher.
Objection, may we approach, Your Honor?
Yeah.
Dr. Kelly, are you aware of any studies that talk about finding no evidence in an increased crash risk with drivers with THC levels less than 5 nanograms?
So if I could restate your question. Am I aware of any studies that show that under 5 nanograms per mil, there is no increase in crash risk
Correct.
due to marijuana? Not offhand, but I wouldn't be surprised. You can find anything in the scientific literature. The preponderance is that it does impair driving though, and that's what NHTSA had summarized.
Would you agree that the THC metabolite is not psychoactive? We talked about that a little earlier.
Yes, I already answered that question in the affirmative.
And it persists in the blood and urine long after impairment has resolved. Would you agree with that?
It certainly can, although
I just want to finish my sneezing because the problem is it will focus on me. Is it possible for you just to turn off my microphone just in case I sneeze or cough again? Okay, that's okay then. I'll pinch it. Okay, go ahead.
So my question was, would you agree that the THC metabolite can persist in the blood and urine long after impairment has resolved?
yes,
And therefore, the metabolite can provide evidence of exposure, but does not indicate impairment. Would you agree with that?
true.
Thank
I mean,
you.
depending on what other information is available, obviously.
You referenced on your direct examination that about the National Highway Traffic Safety Administration's drugs and human facts or drugs and human performance fact sheets. Does that look familiar to you?
Yes,
And are you familiar with that enough if I refer to it?
I think so.
Okay. Would you agree with the assertion in this document that it is difficult to establish a relationship between a person's THC blood or plasma concentration and performance impairing effects?
Absolutely.
You would agree with that?
Yes. It's more about when last use occurred versus the time of the incident than it is the THC concentration. I explained earlier that that can vary wildly.
Would you also agree that the fact sheet states that it's inadvisable to try to predict effects based on blood THC concentrations alone and currently impossible to predict specific effects based on the THC-COOH concentrations?
Yes, and that's why I didn't do it.
And would you also agree that that fact sheet discusses signs of impairment to include blood pressure, odor of marijuana, coating of the tongue, and relaxed inhibitions, poor performance, incomplete thought processes? Are you familiar with all of that?
Yes, I am.
And those were not found for Zaon, correct?
I don't know if they were looked for, Counselor.
Okay, so do you remember when we were talking earlier about the officer, some grand jury testimony?
Yes,
And he testified that he did not see any of those signs in Zaon?
I think my report said something different. I mean, I'm struggling to remember some document I read 4 years ago, frankly.
Sure, let's refer back to your report then. Why don't you turn back to 241 of that exhibit?
Oh, yeah, okay. Okay,
That second paragraph, do you remember we just read that earlier?
we did.
And you agreed with me that Officer Powell testified that he did not observe several other signs and symptoms of potential marijuana influence, including eyelid tremors, coating or blistering on the person's tongue, balance issues, coordination issues, problems speaking or comprehending, cracked eyes, or an odor of marijuana. Do you see that?
Yes, it's all coming back to me now.
Okay, thank you, Dr. Kelly. I appreciate that. So you saw the video. Officers did not note impairment on the scene, correct?
I heard that one officer say no signs of impairment.
Okay, because there was actually two. Did you want me to replay the other one?
No, I'll take your word for it.
Okay. no one found any odor in the vehicle or on Zaon of marijuana use, correct?
I don't remember.
You don't remember seeing that one way or another?
Correct.
Okay, so if I told you that that wasn't found, you'd have no reason to disbelieve me.
Not at all.
Okay. And I want to talk about that Australian study that you referred to. Do you recall that study stating that drivers with blood THC concentrations of over 5 nanograms per mil were higher risks for potential impairment?
Yes, I do.
Do you recall citing to a study from 2005 that evaluated 440 drivers in Switzerland?
Yes,
And the conclusion that that paper came to was that they were correlating police suspicion of impaired drivers with positive results, correct?
correct.
They did not examine the levels of THC in any of those users' systems, correct?
That isn't correct.
It's not correct? They
It's
did
not correct. That's what study, they did tabulate the levels.
They tabulated the levels for each and every participant of the 440 drivers?
Well, what they tabulated was representative statistics. I think what they said with THC levels were between 1 and 35, if I recall correctly, in these drivers, as you said, 440 drivers. And carboxy THC levels were, I don't remember the range there, but it was pretty broad.
That Swiss study, though, included all types of drugs, not just THC, right?
Yes,
It included alcohol, cocaine, methamphetamine.
I don't think alcohol was part of it, if I recall correctly.
Okay, cocaine, methamphetamine,
Correct.
all manner of drugs.
Benzodiazepines, I remember
you.
those being in there.
Okay. And so it was not just exclusively centered on THC levels, is that right?
True.
You are aware that Zaon was not indicted by the grand jury on a charge involving the DUI.
I remember that, yes.
And I believe you said something earlier. When you were asked about the difference in your reports on the may versus probable. And you believed that you could not get to the criminal standard
Yes,
for Zaon's impairment. Is that right?
yes, that's correct.
And I believe you testified here that though you could get to the more likely than not standard.
Yes,
Is that where you draw the line? You can get to the more likely than not standard. You just can't go up to the higher levels.
I don't understand the question, sorry.
No,
In
sure.
general, or in this case, or?
In this case, so you talked about you could not get to that criminal standard, right?
Correct,
You
correct.
felt that you could not meet that criminal burden.
That's true, and I can't do that today.
Okay. But you feel like you can meet the lower civil burden of more likely than not.
Yes, I consider them quite different.
Okay. And my question is, that's where you draw the line. You can't get above more likely than not. That's where you're landing on this.
That's fair.
Thank you. And then as a result, perhaps of partially your work, the DA did not end up pursuing charges against Zaon for involving the DUI, correct?
That's correct. It wasn't only because of my report, but that's what happened.
Okay, maybe in part because of your
Well,
report.
I think so, yeah.
It would make sense if you can't meet that burden. It would make sense.
Because in a lot of their cases, I can say to a reasonable degree of scientific certainty that somebody was impaired. I just didn't feel like I could here, and so.
Do you recall Officer Powell discussing the loss of convergence test?
Lack of convergence.
He called it loss of.
Or did he call it
either way.
Oh, okay.
And maybe he didn't, maybe I wrote it down wrong. Could you turn to 35-0187 in your book, please? And did you review the testimony from Officer Powell that he concluded or has, holds the opinion that the failure on the loss of convergence test did not indicate someone has marijuana in their system? Or excuse me, I said that wrong. Officer Powell testified that someone may have marijuana in their system, but they are not under the influence of marijuana.
True, it's a sign of use, not influence.
So you
I
agree
mean,
that,
it's influence in the sense that, yes, this is a symptom that's caused by marijuana consumption, but that may or may not equate to driving impairment.
thank you. So you agree that the failure on the lack of convergence test does not correlate with impairment per se. It is just a sign that someone may have marijuana in their system.
Correct.
And there were no other signs or symptoms noted by Officer Powell per his grand jury testimony.
And
Correct.
again, I did find in the record eyelid tremors.
And remember when we talked about Officer Powell's grand jury testimony, he indicated that they were not present. Is that right?
Yeah, I think that's what he said.
Okay, wonderful. I have nothing further. Yeah, you're
Need a break or are you okay?
Breaks are always good.
fine.
Does anybody need a break? We can
Especially
take a
when you're
short
old.
one before we take our lunch break. So we could take like a 10-15 and then try to go for an hour and then do our lunch break. Does that work for everybody? Okay, I gotta read you the instruction again. Sorry in advance, but I'll read it as fast as I can. You're instructed not to talk with each other with anyone else about any subjects connected with this trial. You're not to read, watch, or listen to any report of or commentary on the trial by any person connected with the case or by any medium of information, including without limitation, newspaper, television, internet, or radio. You're not to conduct any research on your own relating to this case, such as consulting dictionaries, using the internet, or using any reference materials. You're not to conduct any investigation, testing theory of the case, recreate an aspect of the case, or in any other way investigate or learn about the case on your own. You're not to talk with others, text others, tweet others, Google issues, or conduct any other kind of book or computer research with regard to any issue, party, witness, or attorney involved in this case. You're not to form or express any opinion on any subject connected with this trial until the case is finally submitted to you. Okay, we will take a 15-minute break. It is now 11:22. If you could try to come back by 11:40, that would be great. All right. Okay. Does anyone want to make any kind of record, or do you all want to take a break as well?
I'd like
And
to
if
I
so-
would love to take a break.
Okay, so let's take a break. Do you want to make any kind of record?
I'm good.
Not right now.
Okay. So not right now, I mean, but when we come back from the break, do we need to come back a few minutes early?
I'm good.
Okay, then we'll come back at 11:40 as well. Thanks.
Thanks, Judge.
There you go.